Hello and welcome along to today's webinar, An Employer's Guide to Employment Tribunals. My name is Rachel Lamsley and I'm a Senior Employment Law Advisor here at Ellis Whittam. So before we get started, to listen to today's webinar, please use your computer speakers. As usual, if you've got any questions, please do pop them in the questions box. And if you're having any trouble at all accessing the webinar today, just let me know in the questions box and I'll be able to come back to you after the event. So for those who are unfamiliar with Ellis Whittam, we provide high quality, fixed fee employment law and health and safety advice. We employ qualified solicitors and health and safety advisors to develop one-to-one relationships with our clients, and they help you advise and get you along your HR and health and safety journey. Now, we don't just advise, we provide hands-on support, and we've got a range of additional services that employers can take advantage of. We're currently supporting more than 17,500 UK employers, from startups to national brands, and we really are experts in our field. We're getting some pretty good client satisfaction rates as well, and that's something we're really proud of here at EW. So what are we going to take a look at today? Well, it's all things Employment Tribunal. So we're going to have a look at what is an Employment Tribunal. Do fees need to be paid in order to access the tribunal? What's the process if an employee actually lodges a claim? What are the possible outcomes? Are settlement agreements the best option to avoid tribunals? Some common mistakes, and we'll look at some things to take away after today's webinar. So let's get started then. Let's start with the basics. What is an employment tribunal? Well, in a nutshell, an employment tribunal makes decisions to resolve legal disputes on employment law matters, such as unfair dismissal, discrimination, redundancy, equal pay, unlawful deduction of wages. And in Northern Ireland, we have a slightly different setup to England and Wales. Over in Northern Ireland, we have industrial tribunals, which hear and settle disputes on employment law matters. There are also fair employment tribunals, which solely focus on discrimination on the basis of religious beliefs or political opinion. So as I say, a little bit different to the way it's set up in England and Wales. So in general, employment tribunals are considered to be a less formal approach to a court, and they are open to the general public. The cases may be heard by an employment tribunal judge on their own, or they might form part of a tribunal panel with, say, two lay members, one that usually represents the employer's interests and the other represents the employee's interests. Now, whether you face an employment tribunal or a full panel will depend on the type of claim submitted and the nature of the hearing. The judge and the panel members are referred to Sir or Madam. So just a bit of etiquette for you. Now, there are local offices and hearing venues all across the country, and hearings are generally heard face-to-face, but there might be cases where part or all of the hearing is actually carried out through the use of electronic communication, so for example by telephone. This will be the case if the tribunal believes that this would be the most just and equitable way of hearing that case. So it just depends on the type of hearing that you're attending, whether that be face-to-face or by those electronic communications. Now, we also have the Employment Appeals Tribunal, or what we know as the EAT. Now, they look at appeals on points of law rather than points of fact. For example, you may appeal to the Employment Appeals Tribunal if you think that the Employment Tribunal didn't apply the right law or was perhaps biased towards one party or the other. The Employment Appeal Tribunal can dismiss an appeal, they can allow the appeal and give a different reason, so essentially disagreeing with the Employment Tribunal, or they can allow the appeal and actually send the case back to the same or a differently constituted Employment Tribunal to be heard again. Now, that Employment Appeals Tribunal has an equivalent status to the High Court, and any further appeal will go to the Court of Appeal. So, moving on the hot topic of fees. Do fees need to be paid to access employment tribunals? Well, let's start a few years ago, in July 2013, when fees were actually introduced to access the employment tribunals and the appeals tribunal. Now, the reason behind the fees was to transfer the cost of the tribunal from the taxpayer to those who actually use the service. It also aimed really to put people off from making unmeritorious claims and promote the earlier settlement of disputes. Now, at the time, fees varied in accordance with the type of claim and whether they were perhaps brought by a single claimant or a group. For example, the total fees payable by a single claimant for what was known as a Type A claim was £390. The fees for a single claimant for a Type B claim was more in the region of £1,200. It became widely reported that the introduction of the tribunal fees had resulted in a dramatic fall in the number of cases being brought before the Employment Tribunal. The change was particularly criticised by trade unions, who launched legal action stating that the fees were unjustifiably impacting the right to access justice. They also said that it frustrated the operation of the law and discriminated against women and other protected groups. Now, a review assessing the impact of the introduction of the fees was published by the Ministry of Justice in early 2017. That concluded that the introductions of the fees had fulfilled the desired objectives. It was admitted, though, that while there is clear evidence that employment tribunal fees have discouraged people from bringing claims, there's no conclusive evidence that they would have been prevented from doing so. They also found that there was no proof that maternity or pregnancy discrimination claims had particularly felt the burn of the fees, and decided that there was no reason for the fees, therefore, to be slashed. Moving forward then to July 2017, well, the UK's highest court, the Supreme Court, unanimously ruled that the fees in respect of employment tribunals and the appeal tribunal were unlawful. They concluded that the fees had the effect of preventing access to justice and must be quashed immediately. They also held that the fees were indirectly discriminating against women. This is because a higher number of women actually bring Type B claims, so for example discrimination and equal pay, rather than those Type A claims, and this put them at a particular disadvantage when compared to men. The fees, well, they were gone overnight. The government is now currently in the process of refunding those who actually paid the fees since they were introduced almost 4 years ago. Successful applicants will also be paid interest of 0.5%, calculated from the date of the original payment up until the refund date. And I've got to say that whole process is set to be an administrative nightmare. So moving on then to what is the tribunal process if an employee or ex-employee lodges a claim against you? Well, we're going to go through a bit of a step-by-step overview of what happens when an employee submits that claim, starting with early conciliation. In the majority of cases, before an employee can make a claim to an employment tribunal, they must get in touch with the Advisory, Conciliation and Arbitration Service, known as ACAS. And they've got to do that in order to begin mandatory early conciliation. This requires the employee to contact ACAS, but doesn't actually impose a requirement to enter into early conciliation talks with their employer. The aim of conciliation is to try and reach agreement and avoid having to resort to legal proceedings in an employment tribunal. It is a free and voluntary service, and it's not only used by employees. Employers can also use the early conciliation process if they think there's a dispute or issue occurring in the workplace, which is likely to result in a tribunal claim being issued. If the parties do decide to go ahead and try conciliation, the conciliation role includes exploring the issues at the heart of the dispute so that everybody can actually understand the other party's view and position. The conciliator will also promote the use of internal company procedures, discuss what factors tribunal consider when making decisions, and talk through potential solutions proposed by the parties. What the conciliator can't do, though, is force or advise parties to accept solutions put forward or take one party's side over the other. Conciliation normally takes about a month, but it can be extended by an additional 14 days with the agreement of the parties. If a successful settlement is reached, then a COT3 agreement will be drawn up. Now, a COT3 agreement sets out the terms of settlement of that particular claim or potential claim, which has been agreed between the parties following the process of conciliation with ACAS. Now, it's worth noting here, a COT3 isn't the same as a settlement agreement. They differ in a few ways. For example, a COT3 is simpler, it's shorter, it's typically signed by representatives rather than the individual parties themselves, and the big one here is that there's no requirement for the employee to obtain independent legal advice regarding the terms of the settlement. Now, if conciliation is not successful, or the parties don't want to enter into it at all, the employee can then bring about a claim for their issue in the Employment Tribunal. What will happen is ACAS will provide them with a certificate which provides an early conciliation number, and that number then has got to be submitted on their claim. Now, to initiate the process, the employee's actually got to submit their claim on what's known as an ET1 form. Two or more claimants can actually lodge their claims on the same form if they're about the same facts. Now, this form will explain the nature of the complaint. For example, if they were unfairly dismissed, perhaps they were discriminated against on the grounds of a particular characteristic, or perhaps they're owed holiday pay. It will also ask about the compensation or remedy that they're seeking. For instance, if they're claiming unfair dismissal, do they want to be reinstated? So, for example, get their job back, or perhaps be re-engaged. This is where they get a job with the same employer or an associated employer. Or perhaps they just want to receive compensation. It'll ask for that early conciliation number that we talked about earlier, just to prove that they went through that mandatory process. Now, claims may not be accepted, for example, if they're not on the prescribed ET1 form, they perhaps omit relevant information, or they're outside of the Employment Tribunal's jurisdiction. Do remember, there are time limits for all Employment Tribunal claims. If an employee doesn't bring a claim within the specified period, this means that the tribunal can't hear the claim unless an extension is granted. Now, in most cases, the employee will have to bring their claim within 3 months less 1 day from the date of termination or the complaint or dispute occurring. However, there are cases, such as in respect of redundancy payments, where that's actually 6 months. After the employee has contacted ACAS as part of that mandatory early conciliation process, the time limit for lodging a claim to the tribunal is put on hold for up to 1 calendar month, and as I said earlier, that can be extended by 14 days if necessary. Now, if that ET1 has been issued and the tribunal has accepted it, the tribunal will actually send that document to each party in the claim form. And if, for example, in the case of an employer, you then have 28 days in which you've got to complete your response, which is typically put on a document called the ET3. When responding to the claim, you'll need to gauge how strong the employee's case is, what holes there are in your own case, and whether it's worth considering settlement. My expert tip here has got to be seek legal advice to understand how best to respond to a claim. We deal with tribunal claims on a daily basis, and we can help you draft your ET3 form to make sure it clearly states your case and gives you the best chance of defending it. It's so important to get that document right because it will be referred to in subsequent hearings. Following this, the Employment Tribunal judge will look at all of the documents to see whether there are arguable complaints and defences. If the tribunal concludes that the tribunal has no jurisdiction or there's no reasonable chances of success, the parties will get notified. You then need to start preparing for your hearing. Now, parties will choose witnesses to support their case and prepare all the necessary documents, such as pulling together contracts of employment, notes of meetings, emails, payslips, written witness statements. There's a whole host of documentary evidence that might be relevant. During this process, the tribunal actually has a wide range of case management powers. They have, for example, the power to order somebody to attend a hearing to give evidence, perhaps to produce evidence or particular information. They can also make orders about preparing the bundle of documents that will be referred to during the hearing, and they'll give dates when witness evidence needs to be exchanged. something to bear in mind here is that preparing for hearings takes a significant amount of work. So it's often best to leave that to legal experts to do that for you. Now, the next step in the process is that there actually will be hearings to potentially attend. Now, the first one to consider is a preliminary hearing, and this is where the tribunal may determine any initial issues, discuss and clarify any specific points of the case, assess whether a claim or response should be struck out, or consider the chance of settlement or alternative dispute resolution. You'll be given 14 days notice of a hearing, and it'll generally be carried out by an employment tribunal judge sitting alone in the case of a preliminary hearing. A final hearing, which is slightly different, is where the tribunal will determine the claim or anything that has remained outstanding from the preliminary hearing. There may be different hearings regarding, for example, liability, remedy, and costs. Now, if there are 3 people determining the claim, a decision will be made by a majority. If it is a panel made up of 2, it will be the employment tribunal judge who actually has the second or casting vote. The decision may be announced at the hearing, or it could be followed up in writing afterwards. And in general, a decision will be given within a few days, but in the more complex cases, you can imagine this may take a few weeks. The general rule after the decision is given is that the party who loses must comply with that judgment or order within 14 days. Now, if a party decides that they want to perhaps appeal the decision, they must do so to the Employment Appeal Tribunal within 42 days of the written communication of the original decision. This will be considered by an employment appeal judge, who will consider whether there is a reasonable prospect of appeal being successful. So, what are the possible outcomes a tribunal can consider and of these tribunal proceedings? Well, what I've done here is I've just sort of set out some examples of popular claims, which can include discrimination. Now, in that case, there's no cap on compensation that can be awarded for a successful discrimination claim. The compensation that the tribunal may award may not only cover financial loss, but also personal injury and what is known as injury to feelings. There's also unfair dismissal. In that case, they could order reinstatement or re-engagement with the employer and the employee. Now, those are rarely made. In most cases, an order is made to pay compensation, consisting of a basic award and a compensatory award. The total cap for compensation awards in 2017-18 is £80,541, so a substantial amount of money. Another type of claim that often goes through the tribunal are the breaches of working time regulations. In those sorts of cases, a declaration in favour of the employee may be made, providing the individual with compensation. There's also claims such as unlawful deduction of wages. There, the tribunal can make a declaration and order the employer to repay back the actual money that was unlawfully deducted in the first place. Another consideration is flexible working. In these cases where a statutory request for flexible working was perhaps not dealt with in a reasonable manner, the tribunal may order an employer to reconsider the application or pay up to 8 weeks capped pay. So, if you're thinking about what the potential outcomes could be of tribunal proceedings, they can be very, very costly. So, moving on then, are settlement agreements the best option to avoid a tribunal? Well, the main premise of a settlement agreement is that an employee waives their rights to bring legal proceedings against their employer in a tribunal, perhaps in a civil court, in return for something of value to the employee, which is more often than not a discretionary severance payment. Now, typically, most legal claims regarding statutory and contractual rights can be waived as part of the agreed terms in a settlement agreement, including unfair dismissal, discrimination, unlawful deduction of wages, perhaps entitlement to redundancy pay. However, not all claims can be settled that way, such as claims for accrued pension entitlement or claims in respect of personal injury which haven't arisen at the date of the agreement. Now, from an employer's perspective, there are numerous positive outcomes in settling out of court and not having to go forward and defend a claim in the tribunal. For example, they actually provide a quick end to a dispute or issue when terminating employment and provide you with a clean break. They can actually avoid time, resource, and money needed to defend the claim. They also help avoid uncertainty because at the end of the day, we don't know what that possible outcome is going to be. It will be up to the judge on the day. It gives you peace of mind, given that you'll have sight of final agreed terms that each party is comfortable with. And finally, you can actually rely on confidentiality around a settlement agreement because that usually forms part of the terms put forward by the parties. However, as with all things, we've got to consider some issues with settlement agreements. Namely, they can generate huge amounts of costs for employers to actually settle the claim. It's also not a solution for every problem. And in order to make a settlement agreement binding, there are a number of legal hurdles and requirements. And if you miss something, it actually makes the agreement unenforceable. My expert tip: seek legal advice if you're considering a settlement agreement. We draft these every day for our clients, and you've got to be sure that it satisfies all those legal requirements to be legally binding. If proceedings have been issued, then it might be a better idea to settle by way of a COT3 agreement through ACAS. So, what are some of the common mistakes that land employers in front of the Employment Tribunal? Well, the first one we're going to have a chat about is misconduct. And in particular, if a tribunal is looking at a claim for unfair dismissal, they're going to want to see a fair reason to dismiss and that you've acted reasonably in the circumstances. In those sorts of cases, you've got to follow a fair procedure, which includes investigating the matter, informing the employee of the issue, letting them respond to the allegations, perhaps giving them the opportunity to appeal. If you make a mistake, you could end up in front of the judge. So some common procedural mistakes that we see is that perhaps you decide to dismiss somebody for an allegation of gross misconduct on the spot, so not actually following a fair process. Another risk is where the same person carries out the investigation, disciplinary hearing and appeal. Also, if you don't give that employee the evidence and the information that you're seeking to rely on, that too could end up with a claim for unfair dismissal. Another issue that we see is where there's been no right to be accompanied offered at that formal hearing. You might also fail to give the employee information about the possible consequences of the process. And finally, you might end up in trouble if there's no reasonable investigation. A few other hurdles that we often see employers land themselves with is in respect of the 9 protected characteristics under the Equality Act. So those include age, sex, race, disability, religion or belief, pregnancy, sexual orientation, gender reassignment, and marriage and civil partnership. So hardly the short list. Now, if we take, for example, pregnancy and maternity discrimination, here are some common errors that we see employers make. For example, you might not carry out a general risk assessment, or you actually fail to act on what you uncover from that assessment to ensure the health and safety of the employee and their baby. You perhaps fail to warn an employee of a potential redundancy situation whilst they're on maternity. You might reduce their workload or refuse to give them certain projects because of their pregnancy. You refuse to give them a pay rise because you know that they're going to be out of the business soon. You might actually offer their role to the temporary employee who's been covering their duties because they're perhaps doing a better job. Or finally, you dismiss an employee because they're suffering perhaps pregnancy-related issues. There are also issues that we see come up in respect of absences. Here, you're going to see a higher amount of claims come through the Employment Tribunal because employers find it tricky to deal with all sorts of sickness absence. If it is necessary to dismiss an employee for these types of absences, you've got to follow a fair procedure. For example, you've got to think about disability discrimination and those possible unfair dismissal claims. Now, a tribunal is going to look at the reason for the dismissal. It may be a potentially fair reason to dismiss an employee on the basis of their conduct, if they tell you that they are being sick when actually they're fine. Likewise, it may be fair to dismiss an employee on the grounds of capability if their persistent absences negatively affect their ability to fill their work obligations. An employment tribunal will also look to see whether you've considered all of the circumstances of the individual case. Now, whilst it's not an exhaustive list, they'll also take into account the following things that I'll go through to see whether an employer acted reasonably in the circumstances. So they'll consider the nature of the illness, if appropriate. They'll take a look at the likelihood of the employee's attendance record actually improving in the future. They'll consider the duration and the frequency of those absences, as well as the periods of attendance between those periods of sickness. They'll also have a look at the impact of the absences on the business and perhaps the rest of the team. Now, they'll also be looking for an employer to have followed a fair procedure when dismissing that employee. For example, the employee was given appropriate warnings of dismissal and giving them an opportunity to improve their attendance. In cases of long-term sickness absence, employment tribunals will look at a number of factors, including whether or not you consulted with the employee and explored how to support them back to work. Did you make the necessary reasonable adjustments? Seek medical evidence that confirm the employee is not likely to return, or perhaps they're going to come back sooner rather than later. Have you also warned them that their long-term absence could lead to dismissal? In these sorts of cases, if you get the process wrong, you could certainly land yourself in front of the tribunal. So, to wrap up, what's the few things that I think you should take away with you? Well, employees no longer have to pay fees to access the employment tribunal, and so we've certainly seen a sharp increase in the amount of claims being issued. Don't forget, ACAS early conciliation process is mandatory. That means that the employee has got to contact ACAS before they lodge a claim in the employment tribunal. And then if a claim does come in, they've got to lodge an ET1. Following that, the employer has got 28 days to respond, and do make sure you do that within that time period. And depending on the nature of the claim, different outcomes actually can take place. For example, compensation, reinstatement, re-engagement, declarations, or perhaps a repayment of owed money. And finally, consider whether settlement agreements might help you avoid that employment tribunal. But just remember, there are a number of things we've got to consider before embarking down that path. So that brings us to the end of the webinar today. Thanks so much for joining me. I've really loved having you on board. Today's webinar is actually part of our definitive guide range, and so if you'd like to see a copy of our Employment Tribunal definitive guide, do let us know after the event. One of my colleagues will be in touch to offer you a copy of the recording. Perhaps you can share it within your organisation. As I said earlier, if you've got any questions at all, then do pop them in the questions box. At Ellis Whittam, our advisors are here to help you along your HR and health and safety journey. And at the end of the day, we want to make sure you are complying with your legal obligations, as well as making processes easier and smoother for you. Now, our contact details are there for you, but one of my team will be in touch to see if there's anything further we can assist you with. I hope you have a fantastic day. Bye for now.